Hello and welcome back to Brian Fagan's YouTube channel, where we help you to navigate complex world of Texas family law. I am Brian Fagan, and today we are going to discuss an important topic that affects nearly every divorce case in Texas: car ownership. Specifically, we'll explore what happens to your car during a divorce under Texas law. Understanding how car ownership is handled in a Texas divorce is crucial because it involves both financial and legal aspects. Whether you're aiming to keep your car or you are concerned you might lose it, this video will help with everything you need to know. So let us dive in. First, let's start with the basics. Texas is a community property state, meaning most assets are acquired during the marriage are considered community property and are subject to division between the spouses. This includes cars, regardless of whose name is on the title or who primarily uses the vehicle. Generally, any car purchased during the marriage is presumed to be community property. However, if one spouse can prove that that car was purchased with separate property funds, such as money they had before the marriage or an inheritance, they may be able to claim it is separate property, which is not subject to division. On the other hand, if the car was owned by one spouse before the marriage, it is considered separate property. The same applies if the car was a gift or an inheritance specifically to one spouse during the marriage. However, complications can arise if both spouses contributed to the car's payments or maintenance. When dividing vehicles in Texas divorce, the court aims to reach a fair and equitable division, though it doesn't necessarily mean 50-50. The court can consider several factors: the value of the car, each spouse's financial situation, which spouse needs the car more, especially if they are responsible for transporting children, and whether the car is used for work or daily commuting. For instance, the court might award one spouse a car while the other spouse receives an asset of equal value. If there are multiple vehicles, the car may divide them based on the spouse's needs and the car's overall value. In some cases, the car might even be sold, with the proceeds divided between the spouses. If the car has an outstanding loan, the court might assign the debt to the spouse who keeps the car. However, the loan remains a contract between the borrower and the lender, meaning even if the court assigns the debt to one spouse, the other could still be liable if payments are missed. If you believe the car is your separate property, be prepared to provide evidence such as proof of the car was purchased before the marriage or with separate property funds. Even if the car is community property, negotiating with your spouse can sometimes lead to an agreement without court intervention. Consulting with an experienced family law attorney is crucial. They can help you to understand your rights, present your case effectively, and negotiate on your behalf to achieve a fair division of assets, including vehicles. In conclusion, car ownership in Texas divorce involves more than just whose name is on the title. It's about understanding community property laws, assessing the vehicle's value, and considering the needs of both spouses. Divorce can be challenging, but being informed and being prepared can help you to navigate the process more effectively. If you're going through a divorce or considering filing, seek legal advice to protect your interest. Thank you for watching today's video on the Brian Fagan YouTube channel. If you have found this information helpful, please give us a thumbs up and subscribe to our channel for more insights on Texas family law. And until next time, take care and stay informed. Thanks for tuning in to the end. We understand that divorce can be expensive depending on the situation. That's why we're offering our Do-It-Yourself Texas Divorce e-course. You can get access to this e-course by clicking on the link in the description below. Catch you in the next video.